Hi. Thank you, James. Good morning, everybody. Good morning, my colleagues and the audience. I'm Ali Al-Zaruni, managing partner of Horizon & Co. I have been practicing the law over 20 years. I'm a founder of this law firm, Horizon & Co. We are a law firms, local Emiratis law firms, which grow over 20 years when we have a lots of massive experience on the litigation mainly. So that's introductions, and then we'll let the others to start.
Excellent, thanks. Well, I'll just briefly ask your colleagues to introduce themselves. Sitting to your right, we have Justin. Justin, do you want to introduce yourself?
Yes, good morning. Thank you. My name is Justin Gambino. I'm a senior associate in Horizons. I joined the practice 7 months ago, and I work in the arbitration department where I focus predominantly on construction disputes. And I'm licensed in the United States, a solicitor in England and Wales, and also in Italy.
Well, impressive. Okay, and Ingi Al-Sanubi, please.
Hi, good morning. I am Ingi Sharnubi, working in Horizon Law Firm in the litigation department. I'm practicing the law for 13 years, and I am here with Horizons for 2 years and a half.
Okay, excellent, thank you. And joining us also, we have Marcus Curry, Sean Yates, and Robert Stephen. So Marcus, can you introduce yourself briefly, please?
Thank you very much, James. Good morning to all of you. I'm very honored to be part of this panel today. I am a French and German qualified lawyer, specialized in construction and arbitration. And I've been here in the GCC in this region, in particular in the UAE, for the past 15 years. And I've been working lately for CCC as their senior legal counsel specialized in litigation and arbitration.
Okay, excellent. And I'm sure everyone knows this, but for those who don't, CCC is I believe, the largest construction company in the Middle East. Is that correct? Definitely,
among the biggest in the world, and especially here in the region. Exactly.
And representing another construction giant in the region, Sean Yates. Sean, can you introduce yourself?
Good morning. Yes, I've been here in Dubai for 15 years, and I'm currently general counsel at China State Construction in the Middle East, and I'm a qualified English barrister.
Currently completing a PhD, right?
Well, in the middle of it. I think the completion.
All right, thanks. And representing Dfcsa, the Chief Registrar, Robert Stephen. Robert, I'm sure everyone knows you. Can you introduce yourself?
Good morning, everyone, and thank you very much for the introduction, James, and also thank you very much to everyone at Horizons & Co. for co-hosting this event. It's a pleasure to speak to you all today. As James said, my name is Robert Stephen, and I'm the Registrar of the Dfcsa Arbitration Centre. I've been the Registrar now for a little over 3.5 years. Prior to that, I practiced in the international arbitration practice at Herbert Smith Freehills, both in London, Paris, and in Dubai. I would classify myself as being an arbitration specialist and someone that has predominantly dedicated the last 12 years or so to practice of international arbitration. And I've been in the region now for about 10 years.
Excellent, thank you. But just a brief point of housekeeping from me before we begin. So as I say, we're going to start with a presentation that should last 20 or so minutes before we have a Q&A. We do want to make this as interactive as possible, so if you in the audience have any questions either relating to the presentation or anything else we're going to discuss subsequently, please do use the chat function on Zoom, because we want to hear from as many of you as possible. We'll try to address your questions. Okay, well, I'll turn over now to Mr. Ali Al-Zaruni.
Thank you, James, again. I'll be just briefing about Horizon. Horizon is mainly litigation law firms based on UAE. It has been formed over 20 years. In Horizon, we are very fast-growing law firms on the region. We try to muscle ourselves more on litigation because we love to be I'm a litigator by nature. So that's the reason the ideas behind the firm is to have a more specialized litigation law firms on the region. We have the Horizon is comprised of more than 60 people working or staff working with us on the firm. we have a vast difference experience of lawyers and barristers working with Horizon. We have the experience on both system, which is a civil law and common law system. So we are trying to service the clients on the region on all the levels, because as everybody know that we are on the Dubai, we have so many disputes, which is mix of common law and civil law system. So we have strength the Horizon over 20 years, trying to make it a destination for most of the international company for seeking help of lawyers who's more specialized on litigations. So we have people from a different region. We have barristers on board with us managing the firm, actually massively working with on all sectors, but especially on construction. We are managing a lots of cases which is on onshore courts and as well as a Dfcsa or ADGM courts. Along with that, we have a very strong arms of arbitrations departments, where we are managing a good size of litigation or arbitration disputes on the region, mix of construction, commercial, banking. But to be more specific, we are doing a lots of on construction side and real estate. So most of the major case on the region, actually we have been honored to be a part of those large disputes. Horizon has providing a lots of service to the clients, from arbitration, banking, finance, civil, commercial litigations, criminal and investment and corporate. We and Horizon actually today we choose the topic actually of today as an interim measure, because we are already sensing what's going on the market here, and we know exactly it's when there is a financial issues or there is a recession, always will be the interim measure. It's the first thing everybody actually will think about it. So we try to we choose actually this subject specifically, and I think my colleagues on construction, they already the most people is concerned, because there is a lots of requirement and advice coming from most of the construction company here, because of obvious reason, it is what we can do today with the bond calls and others measures. So the interim measure, it is the main issues today in the market. We actually receiving continuously, daily wise, lots of inquiry about what is how we can do the interim measure, how we will proceed, how we will avoid the interim measure against us. So we actually advising on both sides, so whether it's construction or the employer side. So we receive a lots of questions on this. So what is the interim measure? Everybody will ask this very simple. Yes, for my colleagues, this very simple. Interim measure is very simple for them. For the audience, the interim measure is an urgent application, which we are seeking an urgent decision from the judge to do something to avoid either encashing bond or freezing or attaching the assets before it's disappeared actually. So that is why we are actually the interim measure, what's meaning. So it doesn't require, what is the procedure to take an application, go to the judge, get the decision in 24 hours. That is very practical definition of the interim measure. So of course, interim measure, it's always applied. Now it depends, if we are in the court, we are talking about the court, you need to apply it to the what they call it's urgent urgent judge or interim judge. End of the day, you have to go to the judge with an applications. This interim judge, they have to skim your or read your documents from face of it, and they have to decide it on 24 hours whether they will give an instruction to freeze the bond, for example, or give an order to attach an assets. So that is something which is the main why the interim judge and what the main interim judge he will do. Interim judge, everybody who work on the field, they know that they will never go deeply on the matters. They just need to see what is the application. Is there is a good merit behind that applications? So there is a good reasoning. If there is any a serious or a dangerous, one of the parties of the contract will have it. So he need to give a decision. So it is very sensitive decision. It's very difficult position, but all of us, we know when there is that recession on the market today and there is a pandemic, everybody is aware about it. Everybody got that issues between them. Lots of issues arise between the employer and contractor. So talking about what is the most common now in interim measure, there is several type of interim measure. The most known interim measure is precautionary attachments, and everybody know that precautionary attachments today time it is very vital, and it is actually importance whether it's for construction company or for the employer. Precautionary attachments could be in two, I can summarize it on two things. One, precautionary attachment, so you ask the judge or interim judge to freeze the call on the bond. And the other type of precautionary attachment, you want to freeze the assets of the other parties because your risk of getting recovery of your claim will be very high. So these always, most of the application, which is the precautionary attachments require. Of course, in these days, mostly it's on the bond call, because there is in construction is very well known that there is a lots of bond. So you find a lot of, it's always either employer are seeking for encashment of the bond, or the main contractor encashing the subcontractor bond. So this is very, very, very regularly now happen, and that's why we have a team dedicated to do these kind of things. So other type also of interim measure, it's a travel ban. So when you know that, of course, today time the flight was blocked, but now they are reopening. So you have to go back and run again for a travel ban. And the last 4 months, we have no issues about it because we know that nobody can travel. But today, we have to think about it. So travel ban always also is another way of interim measure, where we are asking the judge to stop somebody or issue a decision not to allow an individual who is responsible about the debt to leave the country till the main claims has been sorted by the competent authority or by the competent court. So that is something which is also, it was very regular, and it will become now very regular again. Security in cost, and there is another, that's the third type of the interim measure. And the fourth one, which is preservation of the evidence, which is, to be very frank, that is the less happening now, and that's require more, it's more, it has to say it's more tougher now, and the people, they don't go on that a lot. So the main thing it's for us, it's the bond freezing, which we call it, and the asset freezing. So that's the two things of, or main two things of the interim measure. Now we'll talk about interim measure on arbitration. I'll be happy to my colleague Justin to elaborate more on these topics, and of course I will always jump in sometimes too, because we are litigators, so you may step on him, but I know that he is he's a very well qualified lawyer who know exactly, and he's practicing this every day. So please, Justin.
Thank you, sir. Feel free to jump in anytime. So the purpose of my presentation is just briefly to give an overview of how interim measures can be obtained in arbitration in UAE. And I think the starting point for our conversation has to be the institutional rules which are most common and the most common centers used in the UAE. So in the UAE, I'd say the three most common arbitral centers are the DIAC, the Dfcsa, which has gained a lot of prominence over the last few years, and of course the ICC, although being based in Paris, still has an office in Abu Dhabi, and it's still frequently used, and you can frequently see it in different arbitration agreements. So all these rules have, in one way or another, they provide for interim measures being awarded by arbitrators or by the courts. The wording might be a little different, but at the end of the day, it's available. But unfortunately, the institutional rules alone are not enough. You also have to consider whether the law of the legal seat, where the arbitration is seated, provides for this. Now, up until recently, the law here wasn't very clear. So prior to 2018, the arbitration, the relevant provisions of arbitration law were found in the civil code. Now, this all changed in 2018 when Federal Law number 6 was introduced. Now, under Federal Law number 6, this is the UAE's first standalone arbitration law. It was arguably very revolutionary in that it made the UAE perceived as a much more arbitration-friendly place. In particular, it was based on the Untitled model laws, but with some distinctions which I'll get to shortly. So the whole purpose of this law was briefly to address the perceived shortcomings that the prior provisions of the civil code were deemed to have. And one of these was, it was unclear whether arbitrators could issue interim relief in aid of arbitration. And now this has been resolved. Under the new federal arbitration law, arbitrators have the authority to issue interim relief, and I think this is a big step forward. Now, the two most relevant provisions, which I draw your attention to, are Articles 18 and 21 of the arbitration law. Now, Article 18 is called General Jurisdiction to Consider Arbitral Measures, and essentially this awards the courts the authority to issue interim relief in aid of arbitration. Now, among the relevant provisions, which I find most interesting, is that it can be, the relief can be awarded either upon request by one of the parties or, interestingly, by the arbitrators themselves. Another important thing, which I think shows an important intent by the legislator to aid arbitration, promote arbitration in the region, is that an application before the court will not stop the arbitration, meaning that they'll move in parallel. And I think, again, this is a very important thing that shows that the region is becoming more and more arbitration friendly. Another thing which my colleague will talk about in a few minutes is that the applications themselves for the courts are dealt with very quickly. So the judiciary understands the importance and the time sensitivity of these interim measures and the need to issue decisions as quickly as possible to aid arbitration and award the applicant whatever relief is deemed necessary if deemed warranted in the first place. Now, if we turn to Article 21, this instead empowers the arbitrators themselves to issue interim relief. And I want to draw your attention to two things in this provision. First and foremost, again, you see the language that it can either be upon request by one of the parties or upon request by one of the arbitrators. They can deem on their own motion that an interim measure is needed. It's a bit more rare in practice, but they still have the authority to do so. Another thing, which I think is very interesting, is that the clause references the requisite standard to award interim relief. So here you can see that the arbitral tribunal will issue such relief if it's deemed necessary under the circumstances. Now, this is obviously a very broad use of terminology, which is obviously subject to some interpretation. And in comparison to other provisions and other institutional rules and laws, it's fairly broad. The other thing I want to draw your attention to are the 5 grounds for which interim relief will be awarded. Now, when it comes to construction disputes, I think the 3 most pertinent ones are the last 3. So if I can draw your attention, for example, to C, which says preserving assets and funds to ensure that an award creditor can recover at the end of the dispute. The second one would be maintaining or restoring the status quo pending final resolution on the merits. Again, I think it's the most important, particularly with regards to attachments against bonds. And the last one, again, shows an important intent by the legislator to promote the arbitral process. It allows the arbitrators to issue interim relief where it's deemed necessary to protect the arbitral process as a whole. So, for example, if one party is taking, let's say, is engaging in conduct which is trying to prolong or disrupt the proceedings, the applicant or the arbitrators themselves can issue interim relief in order to promote arbitration. However, there are some things that an applicant needs to keep in mind when making these applications. One being that it might be required to post security, and it might be required to pay damages in the event that the interim relief, although awarded, is later deemed unwarranted at the end of the dispute. Furthermore, the arbitration law provides that once the arbitrators issue interim relief, the applicant who has been awarded this, this measure has 15 days to seek the arbitrator's written permission to then go before the competent court and seek an order for enforcement. Now, as I mentioned earlier in my presentation, one of the federal arbitration law is broadly based on the Untitled model law, but there are some key distinctions, particularly when it comes to interim measures. So in the Untitled model law, the relevant provision in terms of interim measures is found in Article 17A. And there are 3 important distinctions I want to draw to your attention. First and foremost, the federal arbitration law actually provides for an additional ground upon which interim relief will be given, which is not seen in the model arbitration law. And this is that arbitrators in the UAE can issue interim relief where it's needed to safeguard the subject matter dispute. So let's say the arbitration, the subject matter is a piece of property or a good. The interim measure can be obtained in order to protect the subject matter itself. The second distinction, which I want to flag, which is arguably, is that and potential weakness is that ex parte orders
Sorry to interrupt. Can I ask that the other speakers mute the microphones because it brings you up on the screen. Thanks very much. Sorry, Justin.
All right, sorry about that. Okay, so I was talking about the second distinction between the Interim Model Law and the Federal Arbitration Act. So one potential shortcoming of the Federal Arbitration Law is that you cannot get ex parte relief, meaning that when you make the interim measure application, you have to give notice to the other party. Now, even if your arbitrator or the courts are very quick at issuing the relief, the other side still has notice and might take steps to hamper the underlying purpose of the interim measure in the first place. So that's it. So that's one perceived shortcoming. And then I think a third distinction, which is very important, is the necessary test. So as we talked about earlier in the Federal Arbitration Law, the thing that the arbitrators will consider most when determining whether interim relief should be awarded is whether it's necessary for the dispute. Instead, the model law provides a much more articulated two-part test. And as you can see on the screen, the test is this. Essentially, the applicant needs to show that the harm they would suffer would not be adequately remedied by an award of damages at the end, and that this harm would outweigh any harm that the respondent of the application would suffer by being ordered the interim measure. And the second thing is that the applicant needs to show that they have a reasonable possibility of winning on the merits. So in this case, either the arbitrators or the judge will look at the, not just at the interim application, but also at the overall dispute and whether the applicant can show that they have a reasonable success of prevailing at the end. Now, this language is much similar to another piece of legislation I want to talk about, which is the arbitration law that you find in the Dfcsa. And this is the Dfcsa law number 1 of 2018, and in particular Article 24. So this is much more akin to the model law, For those who don't know, the Dfcsa laws are based on common law principles that are very similar to the ones you see in common law jurisdictions such as England and Wales. As you can see on the screen, it's very similar. But again, I want to draw your attention to the two-pronged test that the applicant needs to show to prevail on the merits. Now, regardless of whether you obtain interim relief by the arbitrators or by a court under, well, especially by the arbitrators, under either the Federal Arbitration Law or under the Dfcsa laws, the question is the same that the applicant needs to make, in the sense that first, once you have an interim measure that's been awarded to you, you have two options. First, the other side might voluntarily comply, in which case it's the end of the matter, or more often than not, you'll have to seek a court order to enforce the interim measure. And on this point, I leave the floor to my colleague Angie, who will talk in detail about court measures. Thank you.
Thank you. Today, I would like to highlight the precautionary attachment, since the precautionary attachment on the bond is one of the most frequent interim measures sought before the local courts. Generally, the UAE courts have jurisdiction to issue an order or to issue a precautionary attachment order, even if they don't have jurisdiction to entertain the substantive case or the substantive dispute. The bank guarantee or the bond is independent from the underlying contract. It's an standalone agreement. There's two types of bonds, which is the unconditional bond and the conditional bond. The unconditional bond gives the right to the beneficiary to encash or to call on the bond without proving any default or delay on the underlying contract. However, the beneficiary will not be able to encash or to call on the bond on the unconditional bond unless he proves that such conditions are met. Now, as per Article 417 of the Commercial Code, the bank shall not be entitled to refuse to make the payment to the beneficiary for reasons relating to the bank's relation with the client or the client's relation with the beneficiary. Now, in order to impose the precautionary attachment on the bond to prevent the liquidation on the bond, there is application that should be submitted before the court. Now we have two judges looking or we should submit the application before. If the agreement is subject to arbitration, so we have to submit the application before the Chief Justice of the Court of Appeal. If the agreement is not subject to arbitration, so the applicant shall submit it before the summary judge. Now it's an urgent application, so the judge shall consider and decide on this application within 48 hours. And this decision is issued on ex parte. This means no need to notification for the other party or the hearings of the other party. Now we have the Article 417 of the Commercial Transaction Code provide that in order to obtain a precautionary attachment order, we have to raise that there is serious and certain ground. Serious and certain ground may include the fact that the project was completed and handed over, or there is a large amount of a large pending amount due to the issuer or to the issuer of the bond. Now there is two different between Article 111 of the Civil Procedures Law of the resolution of the Cabinet number 57 of 2018, which is impose the precautionary attachment on the assets, and the Article 417, which is in relation to the precautionary attachment on the bond. The Article 111 of the resolution of the Cabinet 57 of 2018, that in order to impose the precautionary attachment shall be grounded on serious concerns like smuggle or conceal or flee on the debtor's assets. This application is, as we said, it is already submitted before the summary judge or the chief justice of the Court of Appeal. And in order to challenge this order, we have to file an objection. The objection which the law already granted to us is the grievance. How we file the grievance, and there's time limit to the grievance or no, we're going to talk about it, but I want to just highlight very important thing that once there is imposition on for the precautionary attachment, the applicant shall submit the substantive case or shall file the substantive case within 8 days from the issuance of the order. Now we'll talk about the grievance. Okay. In order to file the grievance or submit the grievance, there is no time limit. But the new law or the new amendment of number 33 of 2020 gave the right to the applicant or whoever the application is issued against, or the concerned party, to file a grievance before the competent court. However, before the competent court, the grievance shall be decided by the court and may be contested by the Court of Appeal unless the grievance is delivered or issued by the Court of Appeal. There is no time limit to file the grievance, while the grievance judgment may only be challenged by way of appeal within 30 days of the issuance of the grievance judgment in Dubai, and within 10 days from the issuance of the judgment in Abu Dhabi. Because there is we have two different judicial. In Abu Dhabi is taking that this kind of application is urgent application, while in Dubai they are taking it as a precaution application. So they grant 30 days for filing the appeal.
So, thank you, Angie. I think we will now, first of all, thank you, Justin, thank you, Angie, and there is, of course, will be a lots of questions, maybe from the audience, but of course, I'll let my colleague if they have any question, because whatever me and my colleagues, we brief it, it is still brief. There is a lots of details which we try not to make it on this webinar, but we try to make it very simple for everybody, and we'll be definitely happy to accommodate any question from anybody. Thanks a lot.
We actually have a question from someone in the audience who asked whether the slides will be made available, whether you'll be publishing the slides. I'm sure you'll be happy to share them, but we can also post them on our website. I guess I'd like to turn to our panelists to get their thoughts on interim measures briefly. So if I can ask you, Robert, for your views. I mean, it's my understanding that offshore arbitral institutions have a fairly wide discretion to order interim measures. The Federal Arbitration Law has advanced a list of interim measures and precautionary measures. There's a lot of change going on. What's your perspective from the Dfcsa, LCIA?
Well, I think an overarching point that needs to be made that supports something that Ali mentioned in his introduction is that we have seen an increase in the use of interim measures, both in an arbitration context, but also in a domestic context. And what I mean by that is that we have seen parties approach the domestic courts to seek interim relief in advance of commencing arbitration proceedings. And then within the 8-day window of opportunity that we've just heard about, they then commence their arbitration proceedings. And we've seen a significant increase in those types of cases where arbitration proceedings are commenced off the back of an application for interim relief. Over the course of the last few weeks and months in, I think, a response to the COVID-19 pandemic. In addition, as an institution, we've also seen an increase, and it's quite a substantial increase, a 300% increase in the use of emergency procedures at the institutional level. And by that, I mean applications for the appointment of an expedited tribunal, so a tribunal appointed quicker than we would ordinarily do so under the rules, but also appointments for applications for the appointment of an emergency arbitrator. So an arbitrator to come in and grant some interim relief to hold the fort until such point in time as a proper tribunal is appointed down the line. And as I say, those applications are as a result, I think, of the global pandemic that we're seeing. Interestingly, of all the cases for applications for the appointment of an emergency arbitrator to provide interim relief, all of those applications have been accepted by the LSEG court, and they have proceeded to the appointment of an emergency arbitrator. And what we have seen is emergency arbitrators appointed in those cases within 36 hours, which is very, very quick. And in all of the cases, we've actually had the emergency arbitrators appointed and hearings conducted the next day and decisions issued the day after that. And so parties that have gone and made those applications for emergency arbitrators to be appointed have ultimately had a decision handed down within 4 or 5 days of their application having been made. That's very, very quick. And I think it really is a response to the urgency of what they're seeking. So excellent from that perspective, and great from the institutional's perspective as well.
Okay, excellent, thanks. Sean, can I get your thoughts on interim measures? I mean, I think I'm right in saying you have relatively recent experience of this. Is that correct?
We do, and I think the context into which we can put this discussion so far of the availability of these interim measures is that the courts are now closed and the arbitration centres are closed for the purposes of physical attendance, but both have made it available to make these applications online. And that's what we have done. We have, in fact, experience of making an application in anticipation of arbitration proceedings and have done so at the courts, to the Court of Appeal, under the Federal Arbitration Law. And we found the process to be very easily available. I think they say necessity is the mother of invention, but in this case, I think necessity has been the mother of adoption, because many of the mechanisms that people are now using in the COVID, in light of the COVID shutdown, were available before, but they weren't so heavily utilized. So the change that we've seen is that people are now using these mechanisms that were available and using them more widely.
Excellent. Marcus, do you have any thoughts?
Yes, I can add that, much to my surprise, I have to say, in the past year, I've noticed more success in applying for precautionary attachments or injunctions against bond callings. Whereas 5, 7, 10 years ago, there was almost a 100% certainty that, especially when you were trying to go against the calling of an unconditional performance bond, there was a certainty you would never succeed with it, because the whole purpose of the bond was to use it like a check and encash it without taking into account the disputes, etc., behind that bond calling. But I've seen more and more in the past year, courts actually approve the application for an attachment or an injunction against the calling of a bond. And I think that shows that the whole concern that existed several years ago, that these bond callings would be abused for financial purposes, have now been respected by the courts here.
You're right.
Okay, great. Look, we have just a couple of short questions from the audience, mainly to Horizon. So I'll ask them now, if I may, before turning back to our panel. So first question is, I think it's for Ingi. So Ingi, can you please specify the difference if the agreement was subject to arbitration or not?
If the grievance is subject, again, please the question, what you said, because I can't hear.
So the question that's being typed is, could you please specify the difference if the agreement was subject to arbitration or not? So I guess the extent to which an agreement being subject to arbitration affects the issues you raised.
The grievance, in relation to the grievance, if the contract is subject to arbitration or not, there is no difference.
Okay.
You have the right to file the grievance at any time, even if there is substantive case before the arbitration center or the local courts.
So is it the questions, I think so, do you want to know whether will be different if there is an arbitrations clause, and because you will take it from the Chief Justice of Appeal Court.
Yeah.
So the grievance will, the process will be in front of him or in front of the first. I think this is what the audience they are asking.
Okay. In this case, for filing the grievance, if that agreement is subject to arbitration, so it should be filed before the Chief Justice of the Court of Appeal. And in this case, you don't have the right to appeal this judgment, but you can apply for a new application to the same judge, the Chief Justice of the Court of Appeal, to lift the precaution attachment or to impose it. It depends on the court decision.
So that the difference is very simple. If there is an arbitration clause, you have to apply it on the appeal court Chief Justice. But if there is not, you are in the first court or the interim judge. If there is a grievance, then it depends on where you apply it. If you apply it on the appeal, then you have to start the grievance in front of the appeal judge himself, not from the first court. So there is some people, they get confused. They still go on the first court for a grievance, which is wrong when you have an order from the higher court, which is the appeal court.
Okay, excellent, great. Another question, this one from Giovanni Minuta. He asks that now the UAE has enacted a new arbitration law allowing interim measures. Do you expect an increase of arbitrations seated in the UAE? Is this going to lead to an increase in numbers? Perhaps Robert also has thoughts on this, but I'll let you answer first.
I think so, and it's not just because of this one change, the federal arbitration law. It made a lot of important reforms to make arbitration more friendly in the region. For example, the right enforcement and recognition of awards, the set-aside procedures, it's all been streamlined, so it takes much less time. And I think it's a hybrid of different things which will promote arbitration in the region.
Okay.
So I think so.
Robert, what's your views on this?
I think from my perspective, the new United Arab Emirates federal arbitration law has provided confidence, more importantly, provided confidence in the United Arab Emirates as a place or a hub for parties to resolve their disputes by arbitration. And I think it's also given the domestic courts an excellent structure for them to make the right decisions. And we have seen the courts making the right decisions again and again and again. Following the enactment of that law. We have seen for quite some time, I think, an increase in the use of arbitration in the region. We've seen all of the local arbitration institutions grow. Take the Dfcsa, for example, we've had 5 years of consecutive growth in terms of our case numbers. And as we look at the first half of 2020, we have seen a 300% increase in the number of arbitration cases that been filed with us. Now that is in part as a result of the pandemic, undoubtedly, but it will also be just part of the natural growth of the institutions in general in this part of the world. More and more parties globally are looking to resolve the disputes by arbitration, and they're looking to the United Arab Emirates, and in particular Dubai, as a place to do that because of its perfect geographical location, but also because of this new arbitration law that provides confidence, and because of the court system that is supportive to arbitration as a whole. And we've seen that with regard to interim measures. You know, going back to the first question, the important point here is there a difference when you have an arbitration clause or not? The important point is the court is recognizing the arbitration agreement. It is providing the interim relief, but it is requiring the party seeking the interim relief to commence an arbitration, if there is an arbitration agreement, within 8 days. And it's giving that relief for a very short period of time in support of the underlying arbitration agreement. And I think that's a really good thing. And then that demonstrates that the local courts, the domestic courts, are very supportive of the arbitration process and the underlying agreement that the parties have.
Excellent. And just one more quick question from the audience before we turn back to the panel. So Dr. Hashim Jaber has asked, what about the process of enforcement or of enforcing the order in front of a local court? How does that work with respect to the new arbitration law?
James, can you just repeat it, because I can't hear you.
Oh yeah, the question is to do with enforcing an order before a local court. The relationship between that enforcement in a local court and the new arbitration law. Yeah,
I think so. Now it's the enforcement issues. It's become more better, much, or let us put much better than before, and that is it's linked to the previous question. That's why the UAE and Dubai, especially, it's become like a center for arbitration, because today time with the new federal law of arbitration, the courts become more clear of how they can make an enforcement, and it is very noticeable that the court today, they are pro-arbitration orders actually, and they actually the numbers of cases which the court they ratify the award and orders, it is much higher than the previous years. Previous years there's a lots of uncertainty about lots of debating points, but today time I can see, and of course my colleagues they are already in the practice, can see it that it is very quick. The process of federal law make it very easy. So it's not a long time, doesn't take a long time. There is a very short time limit, which actually the court actually very respecting that law, and they are enforcing a lot of arbitration award.
Excellent, thank you very much. Okay, I'm going to turn to Marcus briefly if I may. By the way, feel free, but Horizons partners there, feel free to jump in if you have any questions for the panel. But Marcus, I'm curious to know your perspective as a GC. I mean, are you seeing a shift toward litigation as opposed to arbitration, particularly in cases where the parties are from different states or jurisdictions? Are you seeing any change there?
It's an interesting question you ask, because especially as we both shared, all of us before, that there is a growing confidence in the court system here in the UAE with regard to such complex disputes, in particular in construction. However, what you need to bear in mind generally when it comes to litigation, there's always the opportunity for either party to appeal and then even to go into cassation. So that means that you have an uncertain outcome for a longer period of time. And depending on how you evaluate your chances in the conflict, you will then either opt for that uncertainty, or you will want to have a quick and immediate and definite solution, which arbitration gives you as opposed to litigation. Because in most cases, in all cases, their decision in arbitration is final and binding.
Yes, okay.
I think, Marcus, maybe you're in construction always, your guys getting a little bit sometimes struggle which one is better for you guys, should we go here and there? But I think so, of course, because of arbitration, it is more on the more experienced people. So the arbitration on construction, especially construction sector, is out of my own experience. I can see that the arbitration is the best forum for the construction matters, because you can get a very highly qualified expert to understand that. But while if there is a normal or a small matters, which is still construction, you can take the route of the court, because also it's become more efficient process now. Okay, so I think your guys on construction try to pick and choose which one where you can go. But of course, I can understand that the best is for arbitration, and especially in construction, it's the arbitration forum, definitely.
Absolutely, I fully agree with you, Stezali, because as you said, depending on the complexity of the contract, you will have to evaluate. If you have a simple supply agreement, there wouldn't be a problem with, for example, having the courts decide on it. But if you have a very complex construction agreement with various elements into it that need an expert to decide on it, your options are far better to have an arbitration where you can have a panel that has dealt with construction disputes and almost thinks like an engineer, not just like a jurist, to understand exactly the terminology being used, to understand what the claims are about and decide based on that experience.
Okay, Sean, can we get your thoughts on that, please?
I think there are 2 points. One is that the decision as to which dispute resolution process you will use is often decided for you already, because it's written into the contract. And at the time when the contract is written, you have no way of knowing whether any subsequent dispute is going to be complex or simple. The second point is that there are more options in the region. We have the new international commercial courts in Abu Dhabi and Dubai, and they offer an alternative dispute resolution mechanism. Ultimately for us, I think certain cases are more suited to arbitration and certain cases are more suited to a process before the courts or the international courts. I think what we are seeing with this increased choice of resolution fora is there's a sort of race to innovate. And we have many of these different venues borrowing perceived benefits of others and incorporating them into their own. So you have, for instance, courts in the Singapore International Commercial Court. You can choose not to have an appeal level process. So you do get that predictability and commercial certainty of not having an appeal. Likewise, in ADGM, you can opt to have confidentiality attached to your proceedings, which is another perceived benefit of arbitration. And we have some movement in international arbitration trying to have a way of adopting precedent around the confidentiality provision so that you have that perceived benefit of litigation. But one of the things that I think all of these options are moving towards is the ability to deal with applications and hearings remotely. And I see one of the questions that we've been asked by an anonymous attendee is, how are the panel adapting to handling disputes remotely? And I think that is topical at the moment, and it is really testing the facilities that have been offered by the various institutions. And I'll take a few minutes, if I can, just to indicate the types of things that have been happening. So one of the benefits of the federal arbitration law is that they have already adopted some mechanisms and procedures that help in the current climate, even though they're not originally found in the model law. So under Article 33, we have the provision that hearings may be held through modern means of communication without the physical presence of the parties. Under Article 35, the arbitral tribunal may question witnesses, including expert witnesses, through modern means of communication without their physical presence at the hearing. So we have these facilities there, and it comes back to mother being necessity being the mother of adoption, that they're now being used. The arbitration community has lost no time in writing about the effects of COVID, and the arbitration community are very keen to write. Anybody that doesn't write has sort of fallen off the map as far as they're concerned. So we have new resources available. I note that Robert is part of the thank yous on the virtual arbitration website, which is very useful in terms of providing resources for everything that you could think of to do with remote hearings. So we now have apparently remote hearing is the subject of some new skills. You need to learn how to conduct remote hearings, because just because you conducted the garden variety hearings, you don't necessarily have the ability to conduct the virtual ones. So Essex Court Chambers have a webinar coming up which will teach you how to win virtual arbitration hearings. So not just normal ones, but the virtual ones. It's a specific skill. There's some practical advice that's given on the virtual arbitration website in an article that's called Video Conferencing, Gotchas and Tips. And here are three of them. One of them, it relates to the camera position. So if you're going to be on camera, make sure it's positioned so that it's not pointing up your nose or down onto the top of your head. So that's some practical, useful advice. The second piece of advice relates to displays. You want to have two monitors, apparently, not just one. It says 2 monitors or displays are a must, especially for longer hearings. So I assume that that's one for the hearing, and then when you get bored, you need the second monitor to catch up on your soap operas, whatever it is. And the last one that I liked in particular was try not to sway backwards and forwards, because you'll make your audience seasick. So I hope everybody's got note of those, but as well as these new resources, new skills, there's a new virtual etiquette. And I noticed Ali in his introduction said that he's a litigator, so he's used to jumping in. Well, be warned, because the London Maritime Arbitrators Association which has a protocol on virtual and what they call semi-virtual hearings, talks about this new etiquette, and specifically if you want to interrupt. So if you want to interrupt, you have to put your hand up. So any participant other than the speaker who wishes to speak should either put up their hand physically or utilize the virtual hand. You see, we have virtual hands now. I can't find it here, but you press a button and a virtual hand comes up, and this indicates that you want to speak. So I'm going beyond that. I'm promoting the use of the virtual finger, and it's because my usual preferred means of interruption is just to hold up my finger like that. So I'd like a virtual finger as well as a virtual hand, which hopefully can be incorporated. And we have a hitchhiker's guide to virtual hearings. I mean, you wouldn't believe the number of articles. This website was launched when, Robert? Was it this month, last month, June?
Yeah, it's just over a month ago.
Just over a month ago. It's got over 100. It's got dozens of articles that people have contributed. This is the danger at the moment. I think we're getting perhaps too much information. We have new protocols. There are new protocols coming out every week. There's the Hague Conference Draft Guide to Good Practice on the use of video, protocol for online case management, which Robert told us about on LinkedIn yesterday, the Vienna Protocol, the Pakistan Protocol, the African Protocol, the Seoul Protocol on video conferencing, and soon the Yates Protocol on the use of the virtual finger in international arbitration hearings. So maybe that's what the second screen is for. It's actually to make sure you don't miss out on the latest protocol that's been issued that day. So that's what I have to say on the virtual hearings. I hope that answers the some questions.
Yeah, no, thanks, Sean. I mean, you mentioned the race to innovate among the various arbitral fora, so I guess it's only fair to turn to Robert briefly to get his thoughts on that.
I think it's fair, and we've seen a lot of institutions jump to be the first to write articles, to host endless webinars, and to move their business into hosting events and webinars on a regular basis, discussing issues like this. I think there is a fine line, and you have to be careful about what the underlying role of an institution is. And from our perspective, the key thing is the administration of the cases. And so we've been very much focused on administering cases. And I think it's really for law firms and others to be writing articles and producing protocols, etc., on how to conduct virtual arbitrations in a new world. And really, we need to be very much focused on doing the job of administering the cases in a neutral and independent way. And we've largely stayed out of that realm. But I think our contribution to the virtual arbitration website is important because it did fill a gap and a need for people to find information quickly at a time when the world was very uncertain, still is very uncertain, and we need to be able to ensure that the wheels of arbitration keep moving and that we can still conduct the cases in a timely fashion. And I think it largely has worked. And what I've seen from at least an institutional perspective is that arbitration cases are progressing and that hearings are still being conducted, albeit virtually. And I think people are now getting used to the new normal of conducting a Zoom call or similar. And, you know, it's certainly, as I said at the outset of this meeting, the highlight of my day, joining on a Zoom call and looking inside people's bedrooms, garages, sheds and offices. You know, and I think it certainly has been very entertaining from everyone else's perspective as well. So as Sean said, you know, a lot of this was available anyway. The technology has been available for a number of years. It has always been possible to conduct a hearing virtually. In fact, in many cases, parties have been conducting virtual or telephone meetings and pre-conference hearings, etc., etc. Very rarely have people gone and had a long and lengthy virtual hearing, and now perhaps as a result of the pandemic, travel restrictions, etc., etc., that is now taking place. But for those that have certainly experience of that, I think it has been largely positive. It is exhausting. It's a little bit like traveling and being in a part of the world where you're speaking your second or your third language. By the time you get a few hours into the day of doing that, you are mentally exhausted. And it is a little bit like that when you're on a Zoom call for many, many hours. But I think it's just, it's something we all need to get used to. And I think we are now getting used to.
Thank you. I mean, a quick follow-up from a member of the audience, Robert. Hagrib Nut asks whether the DIAC or Dfcsa gives more flexibility on emergency arbitration, so DIAC versus Dfcsa. I don't know if you're able to make a comment on that, which gives more flexibility on emergency arbitration.
Look, I think what I can talk about confidently is what we do as an institution, and I think it's unfair for me to have a comment on what another institution can and can't do under their rules. But from a practical perspective, at least from our institution's perspective, when an application for emergency relief comes in, for an application for the appointment of an emergency arbitrator comes in, we will work 24/7 to ensure that that application is dealt with. And so I can give you a recent example. One was filed about 3 weeks ago on a Tuesday night at 5 p.m. The team worked well into the night to ensure that we had lined up court members, we'd cleared conflicts with a number of arbitrators, and by 12 p.m. the next day, we had comments in from the respondent. We had people that were lined up that were sitting available to be appointed in the specific case that were conflict free. And by 4 p.m. on the day that followed, we were actually appointing one of those individuals, communicating that to the parties, and the process was essentially on its way thereafter. So within 24 hours, 36 hours, we're moving very, very quickly. We're doing that because we want to demonstrate to parties that we can move agilely, that we can give the same level of service that you would expect from some of the leading international law firms. And it's very easy for us to be able to set ourselves apart from other institutions. And I'm not suggesting that it's local institutions, but institutions globally that perhaps are very much 9 to 5. And once it comes to 5 o'clock, everyone goes home, switches everything off. With us here in Dubai, we're very keen to ensure that we are providing a service to those that are sitting in Asia using our services, and those that are sitting in North America using our services, and everything in between. So we have deliberately ensured that the team are working on a staggered basis, and we're able to provide an elongated service. So from our institution's perspective, we're very keen to ensure that these applications are dealt with quickly and efficiently, and that we're providing a level of service that you would expect from a leading international law firm rather than the average institution. How DIAC deals with these applications, I don't know, and I was in private practice in the United Arab Emirates for the best part of 8 years, and I unfortunately never had the pleasure of having a DIAC case where we made an emergency arbitrator application, so I can't even comment on that from a practical practitioner counsel experience. But perhaps someone like Ali might be able to do so, because he's probably got much more experience of working with the institutions other than the Dfcsa.
Yeah, thank you, Robert. I think it's I don't want to because we are practicing with all centers here, and I think so. Robert is correct. It's always depend on the team actually working behind the institute, and that is make difference. Especially on pandemic, we notice actually the difference on reaction from a centers to other centers, not only in UAE, even abroad. We don't want to name the institute, well, but it is correct that we face an issues with for them to coming back, for them to act on even in a small issues. They take a long time because of pandemic, because of they are closing down. But that's giving you actually how the UAEs work, because that is the vision behind the government here, how to make the Dubai and UAE is a hub, because we are sitting on the middle of the world. So if the guys and Roberts and his friends on the centers, they won't be like this. They will not be achieving the target, why they are here, because we are in the middle. From Eastern Asia, they are before us, the Europe behind us. So we have to be always very, very, very dynamic people. I really see what's how the practice happen on at least 3 different centers, and it is I can really raise that's the DIFC LCIA. They are actually very actively doing things, and I appreciate that because it's helped a lot of our clients. Especially if they have to choose which center, that is definitely make a difference for them, especially when talking about construction and the urgency issues and everything. And I saw it's a very robust system, that very active. That is actually which is make a difference. And you are right, Robert. I can't say, but you said it's 100% correct.
Excellent. Let's move on quickly. I mean, we do have questions from the audience, which I promise we'll come to in a second. But Marcus, if I can turn to you, because one interesting thing you were discussing earlier, you told me that you'd noticed a rise of ADR, and particularly mediation in the construction sector. Can you say a few words about that? Tell us what you're seeing in the market. Thank
you, James. It is an interesting phenomenon where in the past, mediation in particular, as an alternative means of dispute resolution, was never really taken too seriously. It was very often inserted in the contracts to kind of slow the process of the dispute escalation and put in another kind of interim phase of revisiting the dispute before actually, going all the way to arbitration. And it was treated by both opposing parties, in my past experience for the past years, almost only as a pass-through, and we were very reluctant to give it more attention than it required. We only considered it as like a condition precedent to actually go to arbitration, and we're very reluctant even to show all of our cards in the mediation. We're reluctant to show our strength to the opposing party as well as our weaknesses. Hence, we're very reluctant to use the benefits that the mediation could give us. And by force of the external factors, such as the lack of liquidity, the need to get a quick solution fast instead of waiting also for a lengthy, costly arbitration to come up with an outcome at a much later time than when cash was needed, we are now giving more attention to the mediation process and giving it more of a chance to actually put the dispute to an end. We also are now more aware of the kind of the psychological phenomena within a company. Very often you have a project team, a country management team that does not convey the full unbiased picture to the actual stakeholders of the company and says, of course we have a good case, of course it's worth going to arbitration. And now I'm talking about the opposing party. And hence the mediation gives us this opportunity for us to talk directly to those stakeholders and to tell them, well, now that you're listening also to us and not just to your own people, do take another look at that claim, or do take another look at that dispute. And it's not as strong as your own people have sold it to you all this time. You may not really want to go to arbitration if you hear our side of the story. And this forum is provided by way of mediation. So now we're actually seeing the potential, seeing the chances in mediation much more than ever.
Okay, excellent. And Sean first, and then I'll come to Robert. I mean, are you seeing similar things in the market? Are you seeing an increase in appetite for mediation among businesses?
I think it's at an early stage. I agree with Marcus that mediation or amicable settlement attempts were often a precondition, still are a precondition to the issuing substantive proceedings. And so there was a desire to show that you'd at least tried that. But I think we have had recently various roadshows like the ICC coming out to talk about their mediation offering. And as an industry, as a tool, I think it is very useful, particularly for the construction industry. But it's one which needs to be developed. We can't have proposed mediators who have not been trained. I think the mediation industry needs to come and do things properly to imbibe that level of confidence. So there needs to be proper training, accreditation of specialized mediators. And I think once they are available, there will be a growth of trust in mediation as an option. And I think there may be take-up in appropriate cases. One of the benefits, of course, is that because mediation or amicable settlement is already built into most contracts, you don't need to wait for a new phase of contracts that are being signed now to end up in a dispute before mediation can be brought in. It's possible to incorporate it already. And of course, one of the benefits is that it's not a zero-sum game like the court dispute or the arbitration result, and it can facilitate the ability of parties to continue working together, which in the construction industry is also very important. So we look forward to the development of mediation and the ability to utilize it appropriately.
Thanks. And Robert, do you have a kind of institutional perspective on this?
Yeah, look, I think we have seen proportionally a higher number of administered mediation cases in the United Arab Emirates than we have seen in London, for example, in recent years. And I think that is just a demonstration of a maturing market and a market that is getting more experienced. As Marcus has said, mediation or stepped arbitration clauses have been around in this region for years and years and years, and it was just seen as something that people had to show or demonstrate some face that they'd gone through the process, but ultimately the key was to get to the arbitration bit as soon as you could, if you were claiming something, and if you were defending something or responding to something, to delay the process as much as possible and to avoid getting to the arbitration process. But we have seen an increase in the number of administered mediations. What Sean has said about there being a lack of mediators in the local market, I think that is right. I think it is difficult to find skilled mediators in the local market. It's a very small number, and it is important to point out that being a mediator, it's a very different skill set from being an excellent lawyer or a fantastic arbitrator or a judge. It's a very, very different skill set, and really you do need someone that is properly trained and accredited in that skill set. And so there are people in Dubai, there are people in the United Arab Emirates as a whole that do this, but it's a very small number. And I think the important bit from the institution's perspective is supporting the local market by educating and perhaps working with others to put together a local accreditation program whereby we can take people that are based locally, train them up, and then have a broader pool of mediators here, rather than flying people in from Europe, North America, or Asia to do it. Because there are plenty of people here that are experienced in construction projects that could be very able mediators. They just need a bit of training and guidance on that process.
I can add to that. I'm raising the eight's finger. Cheers. Thank you. Well,
I didn't raise it.
No, only if I can add to that, especially for the audience. So there are basically two forms of mediation. One is where the mediator is more of a diplomat that is shifting between the opposing sides to especially overcome any emotional obstacles that are in between finding an amicable solution. And then there's the mediator that is almost like a one-person tribunal or an expert that is asked even to give an explained decision on the dispute and evaluate the dispute. And you can have hybrid forms in between, but that kind of confirms what Robert has been saying, that you need, of course, better training and to be able to have that kind of choice between such mediators. I can also add a small anecdote, and this didn't even apply to the UAE, but to London, where we had a mediator and who was so horrible that I guess he was extremely theatrical to overcome his own insecurities. But the inadvertent effect was that we shared that. We had finally something in common with the opposing side because we were both so disgruntled and frustrated by this arbitrator that we finally got together in our joint anger on this not arbitrator, this horrible mediator. But it didn't kind of, wasn't strong enough as a common ground to bridge the dispute, but nonetheless, sharing your opinion that you need good mediators to get good results, absolutely.
Yeah, if I may just interject on the local level litigations and mediation. I think my colleagues, which they said it about an experienced mediator, that is true, because it's totally different being an arbitrator than a mediator. That is really the different skills. You need to know how to balance it, and you need to have a know-how to do that. But I think so on a local onshore rules and regulation here, I think so we don't have still the mechanism of enforcement of this kind of decision, and how these kind of decision will be binding to the parties. This is, I think so, one of the major things. Actually, we have it on the local law level. We don't have any regulations for that type of decision to be enforced, and that is make the parties think several times whether they have to go there, or is it worth it to have a mediator decision, and then how we can enforce it, especially if it is on a local court. So it's very difficult till now, and still there is no regulation. So that's a challenge on our level, actually, on the local federal law.
Okay, excellent, great. We have some questions from the audience. I don't know if anyone wants to jump in and answer these. So we have a question from Helen Graham of Dfcsa, I believe. She asks, if the claimant obtaining an attachment refers to arbitration but fails to pay advance fees to form the tribunal, and the reference is discharged, could the court consider the arbitration agreement discharge? So I'm not sure if that's a clear question that I'm reading out.
If you just repeat it for me, because I have to understand, it's a little bit technical what she asked.
Yeah, sorry. I'm finding the question. So if the claimant obtaining an attachment refers to arbitration but fails to pay the advance fees to form the tribunal, and the reference is subsequently discharged, could the court consider the arbitration agreement to be discharged in that case?
Yeah, if the both parties agreed, and of course the court, they have to agree, unless one of the parties they disagree and then they challenge it. That's another issue, but yes, they can do that.
Okay, excellent. So this next question from Dr. Osama Al-Hajj. Now this refers to a point of Sharia law, ijara, which I'm not terribly familiar with. I think it's the right of the lessee to use property while the lessor retains ownership. But he asks that under the new movables law and the arbitration law, banks are able to strike off the reference of ijara of the customer from the title deeds on a foreclosure case, I believe. So, however, some judgments consider this to be a conventional financing transaction and are therefore asking the banks to refund the money paid by the customer. In light of this, is it possible to take a route through either a special court or an arbitral tribunal, presumably to resolve the issue? What's your opinion on that?
Yeah, I think if I understand it, the question correctly from Dr. Osama, yes, if now that is depending. If there is an arbitration clause, then we can take it to the arbitration, because that is the rule. But if there is, then we need, if there is not available that clause, then we have to parties to agree to take it to the different panel. Otherwise, the courts will be the right actually forum to look at.
Okay, excellent. And sorry, Mr. Ali, we have another question directed specifically at you. This is from Hani Nassar. Again, I'll try to get this as succinctly formulated as possible. I think he gives you a hypothetical scenario. So the hypothetical scenario is this: an irrevocable and unconditional performance bond is issued by a subcontractor in favor of an employer. The employer has assigned the bond to one of the banks as security for a credit facility it's received. So the employer is in default with respect to the bank, and the bank subsequently liquidates the bond. Meanwhile, so while that's going on, the subcontractor has completed the work. Can the subcontractor or the employer submit an injunction to stop the liquidation of the bond?
Okay, if I understand that hypothetical, so just if you can help me, who issued the bond? Is the subcontractor to the employer?
Yes, yeah.
So the subcontractor issued it to the employer, and now the employer asking for encashment or?
The subcontractor issued a bond to the employer. The employer then assigns the bond to the bank as security for a credit facility.
Yes.
Then the employer is in financial difficulty, so the bank liquidates the bond. Can the subcontractor or the employer, can they apply for submit an injunction to stop that liquidation?
That's right. Yes, they can do that. They can go to the courts and say that's the employer has a difficulties and we are worried about our bond. We need to, and we have still a dispute about our outstanding. He need to explain that on the very clear picture to the interim judge. And yes, he has a chance and he has a right to do that.
Okay, excellent, great, thank you. Phew, got there in the end. We have a question which I guess is directed at Marcus and Sean. I mean, we have covered this to some extent, but I'd like to ask them anyway. Remy Redden wants to know, how are construction companies using interim measures? I mean, you did touch on this, but I think the question expands to ask, how often do you think you might need to file for interim measures, particularly in light of market trends and adverse economic conditions? So, Marcus, I'll ask you first.
Definitely, we look into them. Also, for example, the ICC has now developed a lot of interesting interim measures. But then if it comes to the actual action on the ground, I have to say, also in light of one of the topics of our discussion, that you have to go for urgency. You need fast results when it comes to interim measures. And that's why don't underestimate the benefits the local courts give you. So when we're talking, for example, about performance bonds and you want to stop the encashment, you can, take into account the interim measures the ICC provides. But what will provide you the fast and quick result, that will be, for example, an injunction of the local courts. So therefore, we do take them into account because also when it comes to interim measures, you want to increase your options. And as we've been discussing now with the increase of arbitration, we are getting more and more options in interim measures, but you also want to get fast results. And in some cases, it's the local courts that can provide these best to you.
Excellent. Okay. Sean?
Yes, I think the nature of an attachment as an emergency application is seasonal. It depends what's going on in the market. So there's been a lot of talk about bond calls and the attempt to prevent a bond call. That's more common recently because it seems that there are examples of bonds being called preemptorily or unfairly. So we do have those. The other main reason that we might look for an emergency application would probably be to secure against a debt, fearing that the debtor may abscond or that the proceeds may disappear. More recently, but rarely, we might look at anti-suit injunctions as well. But that would be something we would approach the international commercial courts for if we felt that somebody was trying to take a dispute to a forum that wasn't the one that was agreed to.
Mm. Okay.
But how often? Not that often.
Mm.
For all of the applications, not that often.
So if I just interject, I think that the vital things for the construction company is how fast you can enforce or get the order and how fast you can enforce it. That is make a difference on the interim measure actually. That's the reason based on the experience, we are dealing with most of the construction company in the region. They prefer to go to the local courts because the process is fast. The enforcement on the spot will happen different than the other centers because of the enforceability issues. Sometimes, yes, they are too fast on take a decision. Some centers, not all the centers, because I think we tried with ICC, there was still not too, it's much better, but it is not too speedy like local court. But the problem was how we can enforce that decision in case we got the decision. And this is actually, it will be the challenge of the center, how they can enforce it on the region where the bond is there or the asset is there. That is I think so. The main thing, which is any construction company, they will think about it first of all, how you can secure my bond. Okay, then I would choose that one for me. Maybe it's not the best choice, but this is the today choice for me. I have to go because this will secure my bond. Yes, I think this is most of the construction actually doing today.
Okay, excellent. Excellent. Great. I mean, look, I think this was a question, Justin, that you asked the panelists earlier. So I'll ask it now, if I may. It's to Marcus, Sean, and Robert. I guess the question is there a risk that parties to a dispute may look to abuse COVID-19 as part of the arbitral process? I mean, I guess abuse is a loaded term, probably the wrong term here. But Marcus, what are your thoughts on this? I mean, is it a situation that lends itself to abuse? People seeking to delay?
I would say to that, don't underestimate the intelligence of the arbitrators. And they're arbitrators for a good reason, especially when you've chosen them among a panel of worldwide known experts. They will have that feeling that's why even you have appointed them as arbitrators to begin with. They will have that feeling that they're being fooled, that you're trying to abuse the situation just for other benefits. Don't take that risk, because the repercussions will be much larger. It will shed it out on your credibility, on how cooperative you are in that dispute. So don't even go that far. And I've not witnessed it actually in the disputes that even the counterparty has tried to use or abuse the coronavirus for such purposes. I guess because of that awareness of the likelihood of this being discovered and the repercussions resulting from it.
But I guess nonetheless, there has obviously been an impact from the coronavirus when it comes to arbitration, just in terms of the ease of accessing the files, right? I mean, is that something that's affected you in the matters you have ongoing?
Exactly, and that was a very genuine demand because of as a result of the coronavirus, the confinement. Certain files that did not exist as electronic documents were just inaccessible, were in storages in industrial zones that we all know have been at a certain point of time even declared no-go zones. So these files were just not accessible. And that's what we could genuinely prove and share to, for example, ask for an extension of time.
And I guess, I don't know how familiar that is to people outside the construction sector. So you actually literally have to visit the physical site, you have to go to the industrial zone and look at the files in paper copy.
Absolutely. I mean, you're talking about, the whole documentation that is required on a construction site. And I mean, we're getting there to make it as paperless as possible, but a lot of, the recorded schedules and hours of a laborer, they're recorded by hand on paper and not necessarily always computed or put into an electronic document. So when you want to have access to these hard copy documents, they are in a storage, and that can at times be difficult to access, such as in the coronavirus.
Sean, do you have any views on that?
I think the fruit box storage method is something that we see in many industries, but yes, given the accumulation of documents in the construction industry, we have experience of that. I think going back to one of the points that Mr. Ali raised, that there wasn't such a demand at the moment for travel bans because nobody could move. And I think similarly with arbitrations, the delay requests for arbitration hearings are not necessarily unscrupulous attempts by one party trying to delay the inevitable. They're based on a reality that people can't travel and people cannot attend to give evidence, can't visit offices to look at documents. I think there is the risk of due process paranoia that arbitrators sometimes have, and whenever there's a request for a delay, they will give the benefit of the doubt to the requesting party and typically grant a delay. Parties will use any excuse from coronavirus to the dog being sick to get a postponement, and they will continue to do so. But I agree with Marcus that most arbitrators will see through an attempt to gain more time that isn't genuine, and they will probably take it into account. And I think that any prejudice you may suffer from that is outweighed by the possibility of upsetting the arbitrator by jumping up and down and saying they're clearly lying about this. And when you don't really have any evidence to prove it, it's just something that you suspect is true.
Robert, what are your views from Dfcsa, LCIA? I mean, is COVID-19 something that is potentially able to be abused by parties to an arbitration?
I think the short answer is yes. But as Marcus says, it largely depends on who the tribunal are and whether the tribunal are willing to entertain it and to what extent. I think what we saw from a practical perspective in the first few weeks of the COVID-19 pandemic, when largely the world was locked down, that a lot of parties, in fact, the majority of parties, tried to use the pandemic as an excuse to get more time to pay money, more time to produce documents, more time to draft submissions. And I think there was a great deal of sympathy from the institution and also from the arbitrators at that point in time. As we've moved on and we're now 4 or 5 months in, I think the sympathy is wearing thin. I think people are trying to move on their arbitrations as much as they possibly can. We as institutions have demonstrated that we can continue to provide a level of service that is akin to what would be provided if we were sitting in our offices right now. I think arbitrators have been able to demonstrate that too, and I think most leading firms have been able to demonstrate that themselves. And so I think as we move on, the sympathy is wearing thin, and certainly arbitrators are smart people, as are people behind the institutions, and we can see patterns. We have, many parties will have multiple disputes that are administered by the institution at any point in time, and so I can see a pattern very, very quickly if a particular party is asking for a particular delay to pay or a particular delay to produce documents. And if it impacts me at the institution, I can see very quickly if they're pushing a particular line of argument on one case but not on another, if they're trying to get an extension of time to pay a substantial sum of money for one particular case, but they've paid money the week before on another. Likewise, I see very regularly with some law firms, they always wait until the last day that a payment is due, and all of their clients seem to have the same problem, which is the inability to transfer monies from overseas to substantially pay a sum of money to the institution, to the arbitrators on time. And it just so happens that that particular law firm has the same line of argument for every single client, for every single case that they have got. And we can see that pattern, and so we know if it's a try-on or if it's a genuine attempt for some relief. And we as an institution have to very carefully balance up the global issues that are apparent and everyone is suffering them, with the need for the arbitration process to proceed, and also for both parties to have a fair opportunity to have their dispute resolved in a reasonable amount of time. And so, it is a balancing act, and very often, yes, we do give extensions of time where it's within our gift, but they're what we deem to be reasonable extensions of time rather than months and months and months, or unending extensions where parties have just said it's all too difficult, we just can't do it, and so we'll have to come back to you in 6 months' time. And that sort of thing we don't tend to entertain. And I don't think tribunals have entertained that either when it comes to submissions being filed or hearings taking place.
Yeah, excellent. Look, I'm conscious of the time, but I just very quickly want to take a slight detour and ask Marcus something, purely because it's a subject of expertise for him. I gather one thing we haven't touched on here is third-party funding, and obviously with liquidity problems in the markets at the moment, one would expect to see a rise in third-party funded cases. So Marcus, can you perhaps give us a bit of your background on working with third-party funders and your views on whether or not there'll be an increase in such cases?
Well, third-party funding is definitely very, very interesting, very useful, and I really encourage people to take a look at it when it comes to financing a dispute, because very often one of the factors that lead to a reluctance to escalate a dispute, although you have a very good case, you have very good, well-substantiated claims, is do we have the liquidity to finance an arbitration, for example, costs. It's very costly. You need to pay the external lawyers, you need to pay the experts, the arbitration in itself. this is where third-party funding can be a very good option. Then again, you have to be very realistic and then really do the homework, which is what I did when I spoke to a lot of litigation funders. And you see that the litigation funders reasonably are more interested in having not just one case that they fund, but a series of cases, so that they can even out the risks. You know, you might have one winning case and one losing case. If they finance several of these, that evens out the risk for them. But for you as a contractor, the reality is, especially when you deal with those big infrastructure projects that we're dealing with, you're in many times not just the sole contractor, you're in a JV with one or even two other JV partners who might have a completely different understanding or different approach to, you know, third-party funding. And in most cases, you're anyway a company group with various entities, with different partnerships within your group. So to then offer, you know, a series of cases to one litigation funder is not as obvious or not as quickly answered with yes as the litigation funder would hope for.
Okay, excellent. Look, I'll we have a couple of questions from the audience, so if I may, then we can wrap up. So this is a question from Roger Tanios of, I believe, of Indevco in Lebanon. So hi Roger. Roger asks, if an agreement contains an arbitration clause under DIFC rules and there is a breach of the agreement by one party, can the other party request immediate interim measures from the domestic courts before submitting or before starting the arbitration procedures? So I guess either Mr. Ali or Robert would be best placed to answer that. Mr. Ali, can you perhaps give us an answer?
Sure. Based on the practice, if we have a dispute resolution, it's a jurisdiction for DIFC. How the federal court or the local courts, onshore court, how they will look at it. They will read, they have to see on that particular dispute resolution whether the interim measure it's a part of that clause or not. So if that clause is not contained or it's not exclusively saying all the measure, including the interim measure, should be within the DIFC jurisdiction, then the court still, they will entertain the interim applications, and then the other party, they have to go and file it on the right jurisdiction for a substantial case. But if that clause is contained, the substantial or any interim measure on the same clause, which is give the DIFC jurisdiction, then of course the court will, or the onshore court, they will not entertain this kind of application. And if by any chance the judges, he overlooked that clause, then in the grievance it can be squashed easily.
Okay, excellent, thank you. We have another question from Dr. Jaber, which he asks, is the arbitration tribunal empowered to issue an interim measure by one of the parties while the other party is disputing jurisdiction of the tribunal for whatever reason? So the example he gives is, for example, if there's a failure of one party to comply with the requirements of Article 67 of FIDIC contracts and they are then disputing jurisdiction, is the tribunal empowered to issue interim measures?
I think from an institutional perspective, it really depends on the broad powers that the individual tribunal has under the rules, and also the powers that the tribunal has under the law of the seat of the arbitration. And so an arbitral tribunal will be very careful to ensure that it looks at the rules first, and then looks at the law of the seat of the arbitration to ensure it has the power to be able to grant that interim relief. I think from a practical perspective, if you have an arbitral tribunal in an international arbitration that has, with one hand, a party asking for interim relief, and with another hand, a party asking for the tribunal to assess its jurisdiction, I think in those cases, the tribunal will try and do both at the same time, and will try to do both quite quickly. I think it would be a very bold thing for a tribunal to do if its jurisdiction is being challenged, for it to issue interim relief and then take some time to assess its own jurisdiction. But it's a pretty straightforward practice that tribunals generally have the power to determine their own jurisdiction And so the question of jurisdiction is certainly a question that goes to the tribunal to decide. And I think from a practical perspective, most tribunals would assess the jurisdiction and the request for interim relief at the same time and try and expedite that as quickly as possible.
Okay, excellent. Look,
if I may just interject, I think so. In my opinion, personal opinion, it's the interim measure. It's an urgent, and the tribunals, they have to decide it on much faster than the jurisdictional issues. Yes, I agree that they have they are most of the tribunal or the centers now, the rules is giving the competence rules, which is that the tribunal, they can decide it on their own jurisdiction. Yes, but that's require more submission on that. So I think so, if, in my opinion, it's supposed to be, they have to order for the interim, okay, because that at least will stop the risk, then to decide it. If they decided then they have no jurisdiction, that interim will be definitely automatically cancelled. But it's better than to take a risk, because the submissions, I think so. I think I'll need maybe Sean and Marcus to maybe interject here much better, because they already in the lots of arbitration that's the jurisdictional issues. It's require more submissions than the interim one. So there is something urgent. There is some other one. It is important, but it could take more time. So I don't know. I'll leave it for them to, maybe they will give us their thought.
And I think I would, if I was addressing a tribunal, I would suggest that their jurisdiction was an inherent part of the application for the interim relief. That do they have jurisdiction to grant this interim relief? So the fact that there's a separate jurisdiction application pending in relation to the proceedings is a separate matter. I think one of the first things that they would do is say, do we have the jurisdiction? So that the question isn't framed quite the right way, I think.
I think also just, I support what Ali says. A question of jurisdiction is something that takes a substantial amount of time to determine, and as you know, parties go to great lengths to make submissions on that. I think what could happen from a practical perspective under certainly our rules and under the Dfcsa arbitration regime as a whole is that the party requesting the interim relief would make the application to the tribunal, that it could go to the court in the DIFC, or it could go to the court in the United Arab Emirates to seek the interim relief pending the determination of the question of jurisdiction. And I think most arbitral tribunals in those circumstances would say, yes, of course, go to the court to get the interim relief whilst I deal with jurisdiction. And I think that would allow both parties to essentially get what they need, which is interim relief to hold the court pending, or hold the circumstances, and so that everyone's on an even playing field while the jurisdiction question is being determined. Because the risk of asking for interim relief from a tribunal with a question of jurisdiction still outstanding is that you can make a decision on interim relief that would immediately go to a court to be challenged, and you would end up having parallel proceedings, which is proceedings challenging the jurisdiction of the tribunal to issue the interim relief, and then a tribunal determining its own jurisdiction at the same time. And you end up having a risk of at least different decisions being taken, the tribunal perhaps saying it has jurisdiction and the court saying it doesn't. And so I think the safest course of action in those circumstances would be to ask for permission from the tribunal to go to a court to get the interim relief pending the determination of the jurisdiction question.
Okay.
I think you might also just be going under the new federal arbitration law, because I'm not sure whether Articles 18 or 21 require you to establish definitively that you have the right to go to arbitration. This is a precautionary attachment that's taken usually because a tribunal hasn't yet been established in emergency circumstances, and whether or not the jurisdiction was to be raised in the substantive proceedings would be something that would be dealt with later by the tribunal. But in the meantime, you would have your protective application subject to the grievance application that the recipient of the injunction could raise before the courts. But I'm not a lawyer. At least I'm not. Nobody can rely on that. I've got horizons for that.
Okay, excellent. Look, I think we should wrap up there in the interest of time. We have a bunch more questions, but I guess, well, a number of people have asked about slides. Yes, well, with Horizon's permission, we'll post those on our website. I'm sure they'll also be happy to share them if you email them. You can also email me. It's james.wood@legal500.com. You can just go on the webpage for this webinar. You'll find my details. So let me know. I can pass your questions on. But just from me, I want to say a huge thank you to Sean, Marcus, Roberts, for joining us. Great pleasure to hear your views, and also, of course, to Ingi, Justin, and of course, Mr. Ali of Horizons. Thank you very much for a fascinating presentation and discussion.
Thank you. Thank you so much.
Thank you, guys.
Thanks so much.
Thank you.
Have a good day, everyone.
Thanks, and thanks to the audience for joining us. So many questions. Thank you. Okay, good day. Bye.
Thank you.
Thank you.